Welcome to the Prosper Attorney Podcast with Janelle Cremé, your trusted estate planning attorney. Whether you're securing your legacy or protecting your loved ones, Janelle is here to guide you through the essential steps. Stay tuned for expert advice on estate planning, and don't forget, your first consultation is absolutely free.
No one likes to think about worst case scenario, but planning for your child's future is one of the most responsible things you can do. So can you name a guardian for your child in your will? Absolutely. But there's a bit more to it than just picking your favorite relative. Prosper attorney Janelle Cremé breaks down what you need to know to make the best decision for your little ones. Welcome back, everyone. I'm Sophia Yvette, co-host / producer, back in the studio with Janelle Cremé. Janelle, how's it going?
How are you?
Good. So, Janelle, in my will, can I appoint someone as guardian for my children?
Yes, you can. In Texas, it's called a nomination of guardian, so it's not necessarily guaranteed, but it's usually taken into full account by a probate judge.
And so, Janelle, what legal steps are necessary to formally designate a guardian for my children in my will?
That's a good question. So actually, I'm licensed in more than one state, and so I've noticed the difference. I love in Texas that you can put it in your will, but you can also have it as a separate form outside of your will. It's just called a nomination of guardian for my minor children. And it's a form, usually it goes with the will, but you can pull it out separate, have it in both. And part of that is because many people also have a revocable living trust. So they might only need that nomination of guardian. They're not going to have to do the rest of probate. And it essentially says, if I pass away, this is who I want to raise my children. If your spouse is still alive, you're going to have your spouse. And then you're going to say, this is who also I want. And then many people also like to give a reason as a separate form after it. Like, this is why I want these people to. I want them to be raised a certain way. And they can also say, these are people I don't want to be considered. Many people just say, these are my people I want to be considered.
Are there any other legal steps that are necessary in this process?
As long as it is signed in front of two witnesses with a notary, and then usually we want a self-proving affidavit. That just is another signature notary with them so that those witnesses don't need to be called into the court to say, yes, I did see them sign it. They were of sound mind.
So, Janelle, can a court ever override my choice of guardian, and under what circumstances might that happen?
Technically, yes, they could. Generally, it would be if the court doesn't see these people as fit over the children. That would be circumstances that you would probably want it to be overridden. Like, it's not in the best interest of the child. Maybe this person wouldn't pass a background check for safety over them. But generally, the court is going to follow the will of the parents. And the best interest of the child is the general standard for guardianships and children in general.
Are there certain red flags the court looks for to see if they should or should not deem the guardian worthy of looking over the child?
Well, maybe they have some certain things in there, like a criminal background, something like that. Definitely that would be a red flag. If there is maybe something financial, an issue, but if you're setting up a trust or if there's going to be money available to care for them, that would be something that would override certain things. And I would say a criminal background is probably the biggest red flag. Or if there's somebody else trying to come fight over it and they have a good reason to say, no, this shouldn't be. But generally, they try to honor the wishes of the parents.
Is there an example of a time when you have seen this happen where it did go in the best favor of the child?
I actually don't have any examples. I haven't seen any problems with it. And I usually refer it to family court attorneys, but it's the ones that are appointed. The problem usually comes in when there's not somebody appointed and there's bad blood between families. And it's usually the people that haven't seen the child for a while that have money that are going to try and fight for it. But That's why we usually want to put appointments, like a nomination of a guardian in, so that there isn't family coming out of the woodwork trying to take your children.
So, Janelle, if I don't name a guardian, how does the state decide will take care of my children?
That's an excellent question. So they're going to look family members, close family members, and they're going to see who's willing to, and then they're going to do background checks and vet it. They're going to kind of see who they think is in the best interest of the child based off of interviews and who's willing to. And it's not just going to be interviews that way. Usually it'll be who's closest in like the location, who's not going to change your children's life the most, who they think is maybe the healthiest, the most financially stable. But sometimes there's people that are just say, yes, I'll do it. And then they'll, as long as they come back with a clean background check, they might. But best interest of the child is the starting standpoint.
Do you have any final tips when it comes to appointing someone as a guardian for my children or for our listeners' children here, if it comes down to it?
Yeah, think of who is going to raise your children in the same way you would want to raise them. And when you're thinking of a married couple, make sure you think of what would happen if they were no longer married, whether one passed away or they got divorced. If you would still want both of them, we generally want to just appoint one person of the couple just in case, unless you really feel confident, because otherwise they would get joint custody.
Love it, Janelle. We'll catch you in the next episode. Have a fantastic rest of your day.
Thank you.
Thanks for tuning in to the Prosper Attorney Podcast with Janelle Cremé. Ready to take control of your future? Visit prosperattorney.com or call 469-714-2280. That's 469-714-2280 to schedule your free consultation. Protect what matters most. Your legacy starts here.